done before the 15 minutes, so we'll see how that works out.
So we both have a plan.
Okay.
I thank you, and counsel, you may proceed.
May it please the court. Good morning, Your Honors. Anthony Musto on behalf of JDH. Your Honors, reversal is compelled in this case because not only did the state fail to prove that the person that JDH was defending herself against was a law enforcement officer, but the record to the contrary is uncontradicted that she did not do so. And this is important because each of the crimes for which she was convicted, battery on a law enforcement officer and resisting an officer, requires such knowledge as an element of the offense. This case arose at the state fair, at the state fairgrounds. JDH was taking her young cousin to the bathroom when she noticed that there was a disturbance going on involving some 20 to 30 juveniles, including her sister. She tried to be a peacemaker. She stepped in front of her sister and tried to defuse the situation. What she got for her troubles was being maced in the face by one of the participants. And as a result of that, she was in pain. Her vision was completely blurred. All she could make out were figures. She could not see faces. She could not identify individuals. The only other thing she could see were the bright neon lights from the fair's rides and concessions that cut through the fog and so on. As she was so disabled, she was grabbed and restrained by someone. Actually, several people were grabbing at her. That was from her testimony and from the deputy's testimony. And she did what people would normally do if someone's trying to restrain you. She fought back. She pulled away and she pushed at the individual, punched the person in the chest. It turned out that person was Deputy Hamilton, and that's what gave rise to the charges of resisting an officer and battery on an officer. The deputy had observed the goings-on of the 20 to 30 individuals, but she did not see how it started. She did not see JDH get maced. She came upon the scene after all that had occurred, and she found that JDH and another juvenile in particular were yelling at each other. The deputy described the scene as involving screaming, pointing, and cursing. Of note there is that she said nothing about any kind of physical altercations going on at that point. She came on the scene, what she saw and heard was screaming, pointing, and cursing. Now, she did not approach the group as one might expect and go, police, police, calm down, take it easy. Probably would have diffused the situation if she had done that. She didn't. She waded right into the middle of the juveniles and she physically grabbed and restrained my client and pulled her away. And my client, of course, fought back. Even as they struggled, the deputy never verbally identified herself as an officer. She did not identify herself verbally as an officer when she approached the group. She did not verbally identify herself as an officer when she grabbed JDH. She did not verbally identify herself as an officer when she struggled with JDH.
Also, with regard to the record evidence before us, what rule governs our interpretation of that evidence? As the credibility finder, that would be the trial judge in this non-jury proceeding, are we required to interpret the evidence in the most favorable way to support the verdict, or are we allowed to go there and say, well, since the appellant testified there, it must be true? Or how are we bound to look at this?
You, of course, are to take the evidence in the light most favorable to upholding the judgment, which would be in the light most favorable to the state. However, the evidence here is uncontradicted. Everything that I have just said is uncontradicted. There is nothing to the contrary. And the state had plenty of opportunities to dispute that if they wanted to. They had 20 to 30 witnesses that were there. This officer had another partner who was there. The officer stated that she had a video camera on her. They did not introduce that. Therefore, the only evidence that came before the court was the evidence in this regard. And I would point out that the officer's testimony corroborated JDH's statement because she did admit that after she calmed JDH down and took her into custody, she became aware that she had been maced and that in fact she saw that her eyes were tearing and that her sister was helping her and dabbing at her eyes and so on. So while you do have to take the evidence in the light most favorable to the state, I suggest to you that the evidence in the light most favorable to the state still shows that the state failed to prove, and this is the important thing, this is an element of each of these crimes. The state has to prove that she did know it was a police officer. What the state relied upon, both in the trial court and on appeal, is the fact that the deputy had on a uniform. And in many cases, that is certainly sufficient. People become aware of an officer's status through their senses. Often it is the sense of sight. However, in a situation such as this, where the individual does not have a sense of sight to the point that she can ascertain that is a uniform, that is not sufficient. Had the officer identified herself verbally, we might have had a different situation here, but she did not. And I ask your honors to think of it this way. Suppose my client was a blind person. I don't think anybody would even argue that this evidence would have been sufficient to show that she knew it was a police officer. The fact that my client was temporarily blind doesn't change that, because she was blind at the time when she needed to have this
So
knowledge.
I
in order
need to
connect
advise you,
it.
you have lost your sound. Did you accidentally mute?
I did not. Let me.
No, visually we can see that we're
I
speaking,
can
but
hear
there's
him.
no audio. There's no audio.
How
I
about
can
now?
hear him okay.
Anybody help us with the audio? It's on his computer.
Can you
You hear
me?
him? Or am I the only
I-
one?
Yeah, I can hear him okay.
Yeah,
That's me. I'm sorry.
I
it's-
had that problem
it's me.
earlier. There's something going on with it.
Because
Um,
I can't hear anyone.
I'm not sure whether I should pause or continue with the two judges who can hear me. I would.
Probably ought to pause, Mr. Musto.
Okay. I will,
We've
Judge.
got, we
We have
have,
IT,
stop
we
the
have
clock here?
IT going down to
Yeah.
the office. Please stand by.
Okay.
In case you can hear me, help is on the way. Okay, they're going to shut my monitor. We theoretically will return. Wear my hat again, my earphones. Remember you did that.
Test, test,
Let's
test for
try.
Judge
Hey, Mr.
Casanova.
Russo, would
Test,
you be kind
test,
enough to say
test.
something for me so I know if I can hear you or not?
Test, test, test,
testing,
test, test,
checking.
test.
Good morning,
Okay,
Your
you're
Honor.
still not coming and it's at my end.
Okay.
Ted, can you speak, please?
Test, test, test for Judge Casanova. Test, test, test. Test, test, test for Judge Casanova. Test, test, test for Judge Casanova.
Thanks.
Test,
you.
test, test.
Dad, I got you. Can you hear me?
Good, sir. Loud and clear.
Okay. For whatever reason, I can quote Arnold Schwarzenegger and say, I will be back. Here's I'm back. Okay. Let me see what I can do to restore to Mr. Musto some of the time before I stopped it. I know we'll add at least 30 seconds to your time, council, from whenever normally I would have warned you. So hopefully we can do it. I know this took place sometime after your argument about the officer had on a uniform and the comparison to a person who was blind. I was
Okay,
there that part. So
Okay.
that's good. If that helps you at all, I'm sorry for the interruption. Apparently there's the gremlins know that the least technologically proficient person in the court is me, and they always hit me. But will do my best. This is not a cardboard cutout. I'm really here.
understood, Your Honor. And I certainly sympathize with you as someone whose technical skills are about equal to those of the Aztecs. I know what
Well,
you're
hold
going
on.
through.
Now,
So,
Judge Rothstein Yoakum has sent me a message that she can't hear anything. You know, I feel like, what was it, Elo? 2 out of 3 ain't bad, but in this case it is.
Stand by, we're sending IT to Judge Rothstein Yoakams.
And Attorney Dempsey is just hoping that this happens to her.
that's assuming she can hear what's going on.
Very fine point, yes. Since she nodded up and down the affirmative, I'm taking that to be she can.
Okay,
She's astute enough not to unmic, because then we might trigger everything and it might lose her too. And apparently, if I understood correctly, Judge Lucas may have had that problem earlier this morning. Seems to be going right.
Only glitch I had was getting the right camera hooked up. Sound, knock on wood, sound's been okay.
Let's see. 3 years of law school, 25 years on the bench has not prepared me for technology. And the times in between.
yes, I remember the days when I used to write my briefs on a legal pad and somebody typed them for me.
Sometimes my initial drafts of opinions start in that manner only. I take them from the paper and then I do the first typing.
Okay,
Test, 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 test. Can you hear us?
All right, it seems like we've got it, at least temporarily.
Test, test, test. Are we good?
Yep, yep, thank
Okay.
you.
You're
Thank you
welcome.
all for helping us. Thank you all for bearing with us. And as I said, the show must go on. So you have back on the clock.
thank you, Your Honor. Since you indicated, Judge Casanueva, that you did hear the analogy to the blind person, I think I'm probably at a point where I can transition, and I'm just going to very briefly talk about my alternative argument. I stress that I believe that this case should be reversed on the grounds that we've already discussed, but alternatively, I suggest to you that when the officer reached in and physically restrained JDH, she was acting beyond the scope of her lawful performance of her duties, and that would be a basis for a reversal as well. I don't suggest that in approaching the
Oh,
group,
God.
she was doing.
Now I've lost audio as well. This is unbelievable.
Okay, well, we heard you.
I can't hear you, Judge Casanueva. I can't hear
Okay.
anyone.
Please stand by.
We have a
Ned,
time.
if you're trying to talk, I can't hear you. My apologies, everyone. I did not do a good enough knock on wood. I'm gonna go ahead and stop my video and wait for Rita or somebody to come to my office.
Oh, this will be an oral argument to remember. I wonder when they place this online, do they edit out the clauses for technological correction? Conviction?
Good question.
Test, test, test for Judge Lucas. Test, test, test for Judge Lucas.
Oh, is Susan?
Test, test, test for Judge Lucas. Test, test, test for Judge Lucas.
Attorney Musto, your background reminds me when I first started practicing of the old historic courtroom in Lee County, Florida. It had a very similar look.
I have an old postcard of that courthouse. I collect old postcards and I have one of that courthouse. This actually happens to be the background that I was arguing a case in the Florida Supreme Court, and it is the Florida Supreme Court courtroom. And they put it on my computer because it's required, and not having real computer skills, I've just left it there, and that's my background.
It looks quite nice.
Thank you.
Matt,
Everybody, I think this is working now.
Okay,
My apologies.
thank you. I can hear you loud and clear. And
Great.
hopefully, everyone can hear me. And that means Mr. Musto has a moment of a window of opportunity that we're all online and ready to go. So you were-
Mr. Musto, just to make best use of time, I know you were talking a little bit about whether or not the officer was engaged in a lawful arrest. Wouldn't that have been an affray, what you've just described, which would, I know the state didn't argue that, but I mean, just talking out loud, when I read it, that was jumped out at me that it has all the classic indicia of an affray. Why couldn't she have immediately, instead of having to wait, document PC or what have you, just say, oh, okay, I see a big brawl breaking up. I, as a peace officer, need to start pulling people out and extricating them.
Well, my response to that is this. I think that the officer certainly had the right and indeed probably the duty to try to do something about this. But where I think the state and I disagree is I suggest that that right came under the officer's community caretaking function, as opposed to the state's argument that it was based upon the existence of reasonable suspicion of criminal activity. The only activity that the officer saw was yelling, pointing, and cursing. And the officer certainly had an opportunity and should have gone in to diffuse the situation. Where I have a problem is that when undertaking the community caretaking, the steps the officer takes has to be commensurate with the situation. And
Right.
Since all we have here is oral communications, my position is that by seizing her, as she would if there was in fact reasonable suspicion or founded or probable cause, the officer went beyond the scope of her duties. And that's the thrust of my argument.
Okay, and then only other question I have for you, and then I'll let you finish, and field anybody else's questions if they have them. Good, just circling real quick back to your first issue on appeal. It seems to be suggested by the state that there was no sufficiency of the evidence, objection, or argument raised during the hearing because they point out, and you don't seem to disagree, that this is a fundamental error analysis. Is that correct? We're analyzing this under fundamental error?
The second point, the point relating to whether the officer was engaged in the lawful performance of her duty.
Okay, okay.
That is, in fact, being analyzed under fundamental error. And I have cited two cases in my brief, one from this court, the Nelson case at 543 Southern 2nd, that found error of this nature to be fundamental.
Right.
So as far as the first point goes, though, that was
Sufficiency of the evidence was preserved. That's your.
that is correct. The argument that JDH did not know that it was a law enforcement officer was preserved at both the initial and the second motion for judgment of dismissal.
Got it.
So I think that your question basically brought me through what I had to say about the second point. I'm not disputing the officer's ability to approach. What I am disputing is her detention, physical detention at that point, and suggesting that that went beyond what she was within the scope of her duties. Based upon those factors, I will ask that this court reverse, and I will wish Ms. Dempsey much more luck with the connections than I had during my argument.
Thank you, counsel. And way to hang in there.
Good morning, Your Honors.
Good morning, Attorney Dempsey. The floor is yours, and let us hope that everything works for you.
May it please the court. Yes, I hope for better luck. Laura Dempsey on behalf of the state of Florida. I will try to keep it as short and simple as possible, both because that's what the facts show and because of the technological gremlins that are plaguing us today. Firstly, it's the state's position that the judgment of dismissal was not renewed at the close of the case. That's because there's no language in the closing argument regarding we moved the court for such a thing. There's no standard of proof stated besides beyond a reasonable doubt. There's no ruling on a second judgment of dismissal motion. And on the cold record, there's no like clarifying that there's a merged argument. But I know it's a common practice to do such a thing in juvenile court. So even if it was considered renewed, the state's position is that viewing the evidence in light most favorable to the state, they have more than met sufficient evidence to demonstrate appellant had knowledge of the law enforcement officer being the victim being a law enforcement officer. This is demonstrated by the law enforcement officer making eye contact with appellant before appellant punched her in the chest. She was wearing her uniform. The state would disagree with the analogy that appellant was blind during this. She describes being able to see lights and colors of things much farther away from her than the law enforcement officer was. Her testimony was also that she had seen previous to this whole altercation, she had seen the uniform of what the law enforcement officers were wearing around the fairgrounds before, so she would have been familiar with what they looked like. Deputy Hamilton extensively described the amount of time she gave commands, how close she was to appellant as she gave commands, that she gave commands 5 to 6 times. And ultimately, it is a credibility determination which the trial court made. And this was sufficient evidence to survive the judgment of dismissal issue. Moving into the second issue on appeal, reviewing on fundamental error whether Deputy Hamilton was within the scope of her legal duty. As the appellant has said, he concedes the fact that she could intervene in the incident as in her caretaking capacity. In my brief, I cited a case, State versus ARR, which shows an incident where physicality could be used within the scope of the officer's legal duty, or within the caretaking capacity of the officer's legal duty. In that case, the officer grabbed the girl's arm in order to bring her down to a chair and prevent her from getting physical with her mother. So physicality can be used. The difference in the level of physicality used here was the circumstances which surrounded it. This was Deputy Hamilton used the level of physicality in which was required to keep them safe and diffuse the situation.
Well, and the deputy didn't just come in and try to grab her in a bear hug, correct? It escalated to that point when the juvenile wouldn't accede to her commands to stop and stand down.
Correct, yes. As far as the timing of commands, the state would disagree with the fact that first that she describes the deputy describes the whole incident throughout without reference to commands, and then after her description of the events is asked, did you give commands? And she uses the word during, and then on rebuttal it's clarified she uses the word throughout. So it can reasonably be interpreted different ways, but the state's position would be that it would include her approach to the group, her first trying to engage with JDH as she's reaching towards her, as she's trying to restrain her hands, and then ultimately leading to the bear hug and removing from the circle. And we know from the record, obviously, that JDH was not responding to the commands that she was giving her. So again, the level of physicality that was required. And that's what we want the officers to do in order to protect the children. So this is more than enough competent substantial evidence on the record to support that the officer was engaged in the scope of her legal duty. And I believe if there are no further questions, that the state would rely on the briefs for the remainder of the arguments. Judge, you are muted.
I am now unmuted. Counsel, you have your 5 minutes for rebuttal. I appreciate the help. Maybe y'all didn't really want to hear me today.
Thank you, Your Honor. First of all, on the preservation, page 19, motion for judgment of acquittal, even viewing the evidence in the light most favorable to the state of Florida has failed to prove the element of knowledge, which is present in both count 1 and count 2, knowledge that the person was an officer. Similar language on page 37 for the second motion for judgment of dismissal. Second, the state relies upon eye contact. The fact is that the deputy said on page 13 that she made eye contact with JDH. She did not say that JDH ever made eye contact with her. Moreover, everybody agreed that this was very up close. Even if they could see each other's eyes, that doesn't tell her that she's a police officer. The state is relying upon the uniform as the basis for knowing it's a police officer. Seeing someone's eyes does not accomplish that. Counsel mentioned that JDH had previously seen officers at the fair. Of course, there are going to be officers at the fair. She did not say anything about seeing this officer, recognizing the tone of voice, seeing the officer nearby when this was going on. She knew there were officers at the fair. She knows what officers wear. The state also relies on the fact that in a community caretaking situation, an officer can, under certain circumstances, be physical. I agree with that. Someone's about to fall off a cliff. The officer should grab the person and pull them back. The point is that the force must be commensurate with the situation, and because all we had here was verbal statements going back and forth, that exceeded what was appropriate there. I'd like to address Judge Rothstein-Yelkam's comments about that she wouldn't accede to the deputy's commands. I think it's important to note, number one, that the deputy herself on page 9 said she didn't give any commands until the altercation was underway. That's number one. Number two, the deputy herself on page 13 indicated that JDH could not hear her because JDH herself was making so much noise. And JDH, of course, testified that she didn't hear it. So number one, there's no indication, and in fact, the evidence seems to be consistent that JDH never heard the commands, whether it's because she was making noise or whether because it wasn't said, doesn't matter. She didn't hear them. Number two, because she didn't know it was a police officer, all she knew was that someone who was trying to restrain her and attacking her was telling her to put down her hands. Well, if I got my eyes closed and someone's attacking me and that person tells me to put down my hands, I'm not putting down my hands. I'm going to get hit in the face if I do, in all likelihood. So I suggest to you that that does not carry any weight. I suggest to you that the evidence, as I said at the outset, is uncontradicted here, that JDH did not have knowledge that this was an officer. Therefore, these cannot stand. And alternatively, that the grabbing of JDH exceeded the officer's performance of duties, and reversal should be on that grounds. Thank you, Your Honor.
Thank you. Thank both counsel and for maintaining your presence and your perseverance today. We have a panel, we very much appreciate it. I'll allow you to, whatever the technology says, to allow you to, I don't want to use the word escape, to leave this location and go to another. Thank you again so much.
You're welcome.
We will call the second case, the clerk of the and comptroller for the 13th Judicial Circuit, Cindy Stewart versus the state of Florida et al. So, clear.